deal with tonight. And the first bill I want to hear is not because it's mine, but because I think the most people are here to hear this bill. And Representative McAtee's bill, which is first on the calendar, will be able to be heard after she returns from, you got a couple of bills?
Yes,
Yeah.
in
Okay.
finance.
Okay. So you can leave now if you want.
Okay.
Yeah. All right, so the first bill is sponsored by myself. It's House Bill 5902. It's an act related to labor and labor relations, payment of wages. It increases the criminal penalties for wage theft and employee misclassification. And with that, I will call George Nee from the Rhode Island affiliate of the AFL-CIO.
Thank you, Mr. Chairman, members of the House Judiciary Committee. It is. How are we doing now?
That's great.
All right,
Yeah.
all right. Rock and roll. Thank you, Mr. Chairman, members of the committee. On behalf of the Rhode Island AFL-CIO, we are fully supportive of H 5902 and would like to thank Chairman Craven for sponsoring this bill once again. We hope that this is the year that this passes. It's long overdue. And I just want to start off by referencing a study that was done in February of 2022 by the UMass Amherst Labor Center called Workers' Classification and Wage Theft in Rhode Island, which we have sent to members over the years, and I will send another copy of that study out to the members of the committee this week. This study was funded by the Rhode Island Foundation, and it has some very interesting findings, but I just want to bring up a couple. One is that they determined, after extensive research interviewing the whole community, that 9.3% of Rhode Island employers are illegally misclassifying workers as independent contractors. Approximately that relates to about 4.4% of the Rhode Island workforce, which is 20,000 workers. But this is very interesting. They are estimating that payroll fraud is costing the taxpayers of the state of Rhode Island between $25 and $51 million. And that was for 2009. This bill, from our perspective, it's very, very critical that this bill apply to all workers. There's been some discussion about maybe only a few workers or certain segments. This should apply to all workers, because it's not okay for some workers to get cheated and other workers not to get cheated. Every worker has a right to economic security and justice, and every worker counts. This bill is obviously, from our perspective, pro-workers. It protects wage theft and misclassification. It protects the workers from the money being stolen from them, whether that is not being paid the proper amount that they earned, not being paid for all the hours they've worked, or not being paid for overtime. Just like it's not okay to steal from an employer, it should not be okay to steal from an employee. I think it's also very important for people to understand that misclassification, this bill applies to both wage theft and misclassification. Misclassification is wage theft. And the reason it's wage theft is that by misclassifying that worker as an independent contractor, they're cheating the employee, not just necessarily with their wages where they not paying properly. They're not paying into unemployment insurance. They're not paying workers' comp. They're not paying into TDI. They're not paying into Social Security, and they're not paying into the taxation, into the Department of Revenue. So what happens is when that worker gets hurt, has to apply for unemployment, has to apply for Social Security later in life, that money hasn't been paid in. That is cheating the worker. I've already explained why I believe it's pro-taxpayer, because this money could be very easily used and would be much appreciated to the Rhode Island revenue if this figure is anywhere accurate, and we believe it is. And also, this bill is pro-business. Now, when I say it's pro-business, my perspective on that is that if you play by the rules, you have nothing to fear. And in fact, if you're a business that plays by the rules, you may have something to gain, because there's a lot of your competitors, if they're misclassifying workers, if they're cheating workers, you're getting an unfair disadvantage. There should be a level playing field for everybody. And this bill should be feared by people who are beating the system and are bad actors. That's all the people that should be worried about this. If you're running a good business, which I don't know what the percentage is, it's overwhelming number of businesses do the right thing. They should applaud this. They should be here in favor of it. I just want to close with one thing that happened when we were involved in workers' compensation reform in the early 90s. And there was fraud going on both in the employer community and in the employee community. And the labor representatives that were involved in those discussions, myself included, and Armin Sabatoni at that time with the laborers union, and still is a major fixture in the laborers union, as you know, we took the position that fraud is wrong for both employers and employees. And we advocated and supported that if workers were involved in fraud, it should be a felony, in addition to for the employers. So we've stood up when we've seen injustice on either side of the aisle in this situation. And so for all of those reasons, we respectfully ask for your consideration on this, and let's treat workers justly. Thank you very much.
Thank you. Any questions for George? Seeing none. Thank you, George.
Thank you, Mr. Chairman.
I'm going to call forward, I'm going to try to call 3 witnesses at a time. Is Greg Mancini here?
Yes, he is.
Greg, come forward. Adi Goldstein, the Deputy Attorney General. And let's see, the next person that wants to testify is Lori White. Is Lori here? She's out in the hall. Okay. Mr. President.
Thank you. My name is Greg Mancini, and some of you know me and some of you don't, but I'm Executive Director and General Counsel to an organization called Build Rhode Island. We're a trade association that advocates for the union construction industry, and have a board that is half labor and half management. George Nee alluded to a study that was done in 2023 and about how much it's cost in the state of Rhode Island. I think he said between $25 and $51 million a year. In 2009, this body undertook an exhaustive analysis of the cost to the state in wage theft and worker misclassification. And the report issued by you concluded that the state loses $49,852,317 in uncollected income tax, unemployment insurance, temporary disability, and workers' compensation premium annually. Annually. And I think George's comments, or the study he referred to, corroborates that. So this is costing the state of Rhode Island a lot of money every year. And there are studies to demonstrate it costs not only the state of Rhode Island, but other states a lot of money. In 2022, UMass Amherst did a study. And then there's studies done in Pennsylvania, Illinois, Massachusetts, Connecticut, and other states have all come to similar conclusions. Now, in 2000, as a result of the study that you did in 2009, there was a comprehensive rewrite of the state's wage and hour laws. And during that rewrite, you decided to make misclassification a civil violation. Okay. And as a consequence, there have been prosecutions. The problem is the penalties have been insufficient. And let me give you an example. In 2018, a local subcontractor misclassified 27 workers on a construction project that this state gave millions of dollars of tax breaks to right down the street from here. 7 months later, on the same project with the same contractor, there was additional misclassification. And then this contractor misclassified a third time on the same project, receiving tens of millions of dollars in tax credits. And so basically the message was that it's profitable to misclassify your workers, get a penalty by the state of Rhode Island, and continue to work. The penalties are woefully incomplete or insufficient. In addition, between 2019 and 2021, there have been 180 companies charged with misclassification, all right? And this is a rampant problem, particularly in construction, but it's a rampant problem. This past year, there have been 75 company violations affecting 365 workers who've been denied wages legally entitled to, and of course, over and above the tax revenue the state's entitled to. We had done a public awareness campaign the last 2 months, and we found about 59 allegations of wage theft and worker misclassification. Now I ask, why would it be okay to charge a worker for a felony if that worker steals $1,500 from its employer, but not the reverse? I think it's patently unfair. I also think it hurts not only the workers, but as I indicated a couple minutes ago, the taxpayers and the law-abiding businesses. Now, my organization represents 4 different contractor associations, the largest construction companies in Rhode Island. And all they ask for is a level playing field. What's fair is fair. And so, and that's why we're here today. That's why I've been authorized to come here today, is we just want a level playing field. We think it's fair to the worker, and we also think it's fair to the state of Rhode Island. Now, so I'd ask you to ask the businesses that come before us today, isn't that fair or not? Lastly, I just want to leave with this. I used to be the in-house legal counsel to the Rhode Island Association of Realtors. I know a lot of realtors are opposed to this legislation, and I would say they're misguided. They have statutory protection. Title V, 20.5-1, in their chapter that licenses them, provides for a specific statutory exemption for realtors, saying that they are independent contractors by law. So the realtors should not have an objection to this, and I think I have some authority to say that. With that, I am finished my testimony, and if anyone has questions, I'm more than happy to answer them.
Any questions for the witness? Thanks, Greg. Adi.
Great. Thank you very much, Mr. Chairman. Chairman Craven, Representative Caldwell, Representative Bennett, and Representative Morales, thank you very much for sponsoring this legislation, and thank you, committee members, for your attention today. It's an honor to appear before you on behalf of Attorney General Nerona. He sends his regrets that he cannot be here personally, but he is, I'm sure, watching me right now as I'm testifying from home. Although I do hope he has something better to do. This bill is a resubmission of legislation that this office has introduced for the past 3 years. It has been a top legislative priority of this office. Simply put, the purpose of this legislation is a matter of fundamental fairness. It's premised on the very simple principle that theft is theft, fraud is fraud, and it should be dealt the same way as other thefts and frauds are dealt with, and that when employers knowingly and willfully, when they deliberately misclassify their employees, and when they deliberately fail to pay them wages that they are due, they have committed felonies, and it should be treated as such. You've already heard very effective testimony from my friends George Nee and Greg Mancini regarding a fair, level playing field, both between employees and employers, and across the board amongst employers. It is not fair that some employers benefit from repeatedly breaking the law and gaining an unfair advantage in business. What do these bills do? These bills reclassify wage theft and misclassification of workers from misdemeanors, which they currently are, to felonies. Right now, no matter how much money you steal from your employee, whether it's $100, $1,000, or $10,000, it's a misdemeanor. That's not fair. If an employee steals from their employer, you already heard, frankly, if they steal more than $100 from their employer, it could be a felony because that's embezzlement. It aligns the penalties for wage theft with the penalties for larceny. Okay, so just as larceny of $1,500 or more, okay, is punishable by a term of up to 3 years, theft of wages of $1,500 or more, up to $5,000, should be punishable by the same penalty. And the penalties progress in exactly the same way as those penalties are in the larceny bill right now. Again, there should be no difference between stealing a pet, a refrigerator, or any other commodity and taking money out of the pockets of your workers, of your employees. Likewise, with misclassification, what this bill does is it reclassifies misclassification from a misdemeanor to a felony, okay? For a violation that is knowing and willful, that is purposeful, that is going to be punishable by a term of imprisonment up to 3 years, okay, and twice the value of wages or up to $10,000, whichever is greater. And for a second or subsequent violation, again, knowing and willful violation, for up to 5 years in prison. This legislation is about recognizing that these crimes, theft from hardworking Rhode Islanders, amount to felonious conduct and should be treated as such. But I do want to point one other thing out. This legislation is not just about punishment and deterrence. It's also about giving the Attorney General's office and the courts, frankly, important tools that they don't currently have in their toolbox to deal with this issue. So what are some of the benefits of reclassifying these offenses from misdemeanors to felonies? One, it would allow us to extradite bad actors. A lot of these companies are from out of state. It's much easier to extradite somebody on a felony. It would allow us to use the grand jury as an investigative arm. Again, some of these cases can be very complex. Okay? They can involve a lot of witnesses, a lot of players, documents, tax records, and the grand jury would be an absolutely necessary and effective tool in investigating it. It would also bring these cases to Superior Court, where the court would have a longer period of time, okay, to order restitution to be paid. So right now, if the court it's a misdemeanor and it's in district court, you only have up to 1 year. In Superior Court, obviously sentences can be far longer, and you have a longer time to order restitution. You also have the power of the court to ensure that penalties are in fact paid. Right now, many of the penalties that are imposed by DLT remain unpaid. In fact, I think maybe over 50%. They impose the penalties, and then what? They have to go to collections. You've already heard these are not sufficient or effective tools to deal with this problem. So by reclassifying these offenses, we're going to have additional methods to deal with the worst actors out there and hopefully deter others. Thank you very much for your attention, and I'm happy to answer any questions.
Any question for the Deputy Attorney General? Oh, yes, Dave.
Deputy Attorney General, so where's the boundary between the civil and the criminal offense?
As you can see, the proposed bill sets it's called a mens rea requirement, knowing and willful. You have to show knowing and willful conduct. In the wage theft, there's an additional requirement of $1,500 or more. Below that, it's a misdemeanor. It currently is.
If someone settles within the civil side, could that be used as evidence in a criminal case?
It may or may not be. To prove a criminal case, we would have to prove all the elements of that case. So we would have to prove that that employer acted with the requisite criminal intent, that it was knowing and deliberate, knowing and willful conduct. We'd have to prove each and every element of the case. So it really depends on each individual case.
And traditionally, in a large company, when a criminal or a felony charge is placed, who actually winds up doing the time?
Again, I think it depends on what your evidence is and who you show, who you can prove had knowledge and culpability. So in criminal law, there are certain actors that may bind the corporation, their officers, their high-ranking officials. And again, depending on what your evidence show, you would have to prove that the person acted knowingly or willfully or was sufficiently at the top of the corporation in order to bind it. Just as in any other criminal case right now that we have, where we may go after a business or individuals.
And I don't know how much experience you have just generally in terms of dealing with a larger corporation versus, say, a smaller corporation. You know, we're talking, a general contractor versus a large construction company.
Yeah.
How often would you say you're able to prove that knowing and willfully element against, say, a small contractor versus a larger corporation?
Yeah, so Representative Place, I was a federal prosecutor for a long period of time. I prosecuted both individuals and businesses. I worked in private practice for a shorter period of time where I represented companies. And in every one of these cases, the requirements are the same. Prosecutors have to collect the evidence and go based on what that evidence shows. In larger companies, it may be more difficult because you have multiple actors, but as you probably know from prior criminal prosecutions, particularly federal ones, they've gone after some pretty large companies and were successful in doing so. So again, I think that it's hard to generalize. As you can see, there has not been a slew of prosecutions under either wage theft or misclassification. Wage theft is a crime right now. These are misdemeanors right now, right? And the reason is you have to have the evidence. You have to have the facts, okay, and the witnesses. And that's what our prosecutors do each and every day. They evaluate these cases based on the evidence and proceed accordingly.
Thank you.
Thank you, everyone, for coming today and testifying on this bill, which I totally support. I just have one technical issue, and it's a little thing, but I don't know, since we're writing it, we might as well fix it. In the operative paragraph, so on page 1, it's lines 15 through 18, and down later on page 2, it's line 30 and 31. The language says, where is it? Upon a plea or conviction shall be subject to the following penalties. I would, if I were drafting, I would tighten that up because, a plea of what? And conviction is both finding of guilt combined with sentence. So a crafty lawyer
Sure.
might say, I'm not convicted, so you can't penalize me, and you can't convict me until you penalize me. So just for what it's worth. Thank you.
Any other questions? Thank you, Adi.
Thank you very much.
Lori White from the Greater Providence Chamber of Commerce.
Thank you, Mr. Chairman and members of the committee. Good evening. My name is Lori White, and I'm the president of the Greater Providence Chamber of Commerce. We are a statewide chamber, and I am here tonight with many of my colleagues from other chambers of commerce throughout the state, and also many of my business colleagues and other trade associations that have an important role to play in representing business interests in Rhode Island. So specific to the Greater Providence Chamber, we represent major employers. We also represent mid-size companies, startup companies, entrepreneurs, and many small businesses. And the diversity and the degree to which our membership is quite diverse allows us to come in with some overarching comments on the themes that are associated with this bill and why the Greater Providence Chamber of Commerce strongly opposes the bill as drafted. So tonight you will hear various perspectives, and I might describe them as use cases from many of my colleagues who will come in and share with you specific unintended consequences and ways in which this bill would be overly draconian to those that may in fact be subject to these vague provisions outlined in the bill. So first, some context, some overall context. Let me just say that today, here in 2023, in the aftermath of the pandemic, it is fair to say that many employees are affirmatively going for the fact that they want to be organized as an independent contractor. It is a very legitimate business model, as you all know. And why are they doing that? So a lot of newly registered independent contractors are considering themselves, want to be in a position where they are have a more flexible lifestyle. They don't want to be attached to any one employer. They want to have freedom. They want to have the flexibility to take care of children, to be childcare providers, to go to their kids', soccer games in the afternoon. They may have elder care issues. They might not want to work full time as as an example. So they may have entrepreneurial ambitions. A lot of small business owners, a lot of small business professionals start off as independent contractors, and they specifically are going for that status as a legitimate status, particularly in light of COVID. So just as, Zoom meetings are not going away, the notion that people want to have and be in charge of their own career and their own destiny and whom they work for and at what point along the processes, you're going to see a lot more of this happening, not just here in Rhode Island, and it already has throughout the country. And Rhode Island needs to continue to be positioned as a place that welcomes independent contractors and very firm definition of how that sort of entity is structured. I agree wholeheartedly with my colleagues. I've done a lot of work with Greg, with the building trades, and all of our friends with the unions. We have many commonalities, and couldn't agree more that we want to weed out the bad actors, expressly for the reasons that were documented tonight in terms of having an unfair playing field for those businesses that are not playing by the rules, that are skating, below the radar, if you will, competing against legitimate employers who are doing the right thing by paying their employees fair wages, also benefits, contributing to the tax coffers, and also providing the necessary insurance necessary to be a legitimate business. And we know that this is especially true in the construction trades, which I've had a lot of conversations, with my colleagues, with Greg in particular, around some of the matters that are very specific to that industry. So yes, totally agree. We want to weed out the bad actors, and we have no tolerance for that. Secondly, I want to mention that we know that there is a labor shortage, a talent shortage today. Employers cannot get the talent that they need to fill jobs. So by necessity, because there is specific, these are, a lot of the jobs that are open and available today are very specialized jobs. There are opportunities where it is difficult to attract talent, particularly during heavy seasons, cyclical industries where, you might need to bring on additional talent to get through, tax season or anything like that. A lot of tech workers are very specialized talent. So it's not for lack of employers not wanting to bring on employees and pay them wages and salaries and benefits under the traditional structure. We are in a very unique situation, as you all know, where major employers and small employers are finding it very, very difficult to get the people that they need to run their businesses for short-term assignments. And this legislation would be very damaging because it is vague and because it is inconsistent, and in some places it is contradictory to being able to provide that atmosphere for the independent contractor to flourish and for employers to be able to get the talent that they need, quickly for short-term assignments. And finally, the third aspect, which is the most problematic from our perspective, is that the definitions are vague, they're confusing. Conscientious employers want to do the right thing, the employers and the businesses that are part of the Greater Providence Chamber of Commerce and make it their business to want to be associated with the Chamber and other membership organizations similarly situated. They want to do the right thing. They want to have the proper guidance. They want to know where the guardrails are, and there are many, many aspects of conflicting statutes that cover the definition of employees. And I know later tonight you will hear from other representatives of the Greater Providence Chamber of Commerce who will detail where specifically the definitions may be at odds with one another and how we might remedy that. So in summary, we appreciate the overall aspirations of the bill, the notion of really weeding out the bad actors, but we must do it in a way that does not punish workers or punish employers that are seeking to do the right thing, that doesn't punish independent contractors who are truly looking in many cases to, use the independent contractor status to scaffold their business to be able to go to the next level. And, we are especially appreciative of the notion that we don't want to put any conscientious employers and make them subject to a felony and potentially serving time in prison that is punitive, considering the fact that the definitions at this point as drafted are vague and confusing and inconsistent. So that concludes my testimony. Thank you for listening, and thank you for appreciating the overall context that I'm laying out here tonight.
Okay, any questions? I'm going to call up 3 new witnesses, and then I'll read a couple of people that do not wish to testify but have taken a position. The first person I'll call up now is Christopher Cortese, I think it is, from NFIB, Liz Catucci from NRICC, and John Simmons from RIBC. Are any of those other 2 here? Yeah? Coming in? Okay. And while we're waiting for everybody to get settled, Bill Murphy from the Rhode Island Manufacturers Association doesn't wish to testify, but is against. Kerry Bennett from AGCRI is in favor, doesn't wish to testify. And Rick Fritz from Delta Dental is against, but doesn't wish to testify. Hi, Billy, how are you? All right, you're in charge.
Thank you, Mr. Chairman. My name is Christopher Carlozzi, and I'm the State Director for the National Federation of Independent Business, NFIB, here in Rhode Island. We represent hundreds of small and independent business owners in all types of industry, including manufacturing, retail, wholesale, service, agriculture. We also represent many self-employed individuals that choose to work as independent contractors. While I submitted written comments, it is important that I voice our concerns regarding House 5902. First, we fully agree that wage theft should not be tolerated in Rhode Island. Workers deserve what they are owed for their work. But this bill instead raises more questions than provides answers. What happens in the case of legitimate classification disputes over the status of a worker? Also, legitimate disputes over pay. Will this only further complicate the ongoing struggle to define workers and self-employed individuals if businesses are facing felony or criminal charges? And what will this mean for the growing number of freelancers in Rhode Island? I won't retread on some of the territory discussed earlier. We, representing businesses that contract with self-employed individuals as well as independent contractors, are particularly concerned with the language that makes misclassification of workers a criminal offense with increased penalties. Legislatures and courts have long struggled to find the correct language to define the difference between an employee and self-employed. Even more concerning are other bills proposed this very session that can fundamentally change the definition of employee, pending right now. Legislation that could make it virtually impossible to be considered self-employed in Rhode Island, further muddling the business-independent contractor relationship. In states like Massachusetts that have a similar test to what is being proposed in Rhode Island, that law resulted in self-employed individuals losing work. It's led to more stringent definitions, and if not selectively enforced, could result in many businesses being considered in violation, not because they're attempting to misclassify, but because they're working with legitimate self-employed individuals, yet they're ensnared in this law. Those are the self-employed individuals that do not want to be an employee of a business and choose on their own volition to be self-employed. This type of scenario, coupled with this bill, could mean serious criminal charges against businesses who are under the impression they are being compliant. Wage theft should in no way be taken lightly, and we feel Rhode Island already possesses the ability to battle wage theft violators without the need for this legislation. NFIB opposes House Bill number 5902 in its current form and feels genuine misclassification disputes may result in severe penalties for Rhode Island employers acting in good faith. Thank you.
Any questions? Jason?
Can you give us an example of a misclassification, like some sort of real-world example of what you're talking about?
Yeah, absolutely. I mean, you find in many cases somebody is saying they want to work on their own. They want to, in an example, let's use a book editor. I'll use an example. I represent 2 states. I also represent NFIB in Massachusetts. And when Massachusetts passed their changes to the independent contractor law, it was very muddied, very muddled. We had a business owner who, independent contractor on his own, did book editing. And he got a call from a Rhode Island firm that he was working for, contracted with, who said, this law is far too confusing. You could be considered, technically, if we look at it, an employee here. And that confusion led to the scenario where that person, technically under Massachusetts law, if a case was made, could be considered an employee based on that definition. And therefore lost that contract, lost the job, because they didn't want to have to classify that person as an employee because they felt they were working with a legit independent contractor.
So the company in that case called the person that was doing work for them and said, we're uncomfortable with the scenario under which we're working, so we're going to let you go?
Unfortunately, they had to not let them go, but cut the contract is what happened.
Had to or chose to?
Well, chose to because
Okay.
they didn't want that relationship changed because that's the way their model was.
Could that company have hired someone to fill the slot?
I suppose if they chose to, but they were working with independent contractors. That's what happens in a lot of editor, book relationships.
Was the
Publishing relations.
editor, was his business formed under some sort of legal entity such as an LLC?
I'm not certain the specifics of that. It was a company outside of Massachusetts at the time who was contracting with a Massachusetts self-employed individual.
That's why I bring it up.
Yeah.
I mean, when the Deputy Attorney General says that they have to do the investigation and they have to find all the facts, they're not kidding. I mean, I've dealt with these fraud cases in a variety of contexts, and I know from experience, long-time experience, that the Attorney General doesn't bring these cases unless the theft, in this case, is just really clear-cut. Because no one wants to go into court where you have to prove something beyond a reasonable doubt. This isn't civil court. This is a unanimous verdict by 12 people after hearing all the evidence. And you don't want to go in with a slipshod case. Moreover, in criminal prosecutions on this kind of things, there's often a safety valve or a back door when there's money on the table. If the defendant can come up with the cash to cover the alleged theft or loss, that will mitigate the case somewhat. So I think that, I know it's a little loosey-goosey, there's a gray area, and it's constantly changing because the nature of work is changing. I totally get that. But I think that we can put enough faith in the standards and systems that we have set in place already, which seem to work, because no one's come to the General Assembly and said, oh my God, there's a sudden epidemic of people who think they're employees but they're not, or people who think they're independent contractors but in fact they're employees and nobody can find. That's not happening. And here we have, but what is happening is that there are people out there who cheat their employees out of their labor, and they do it consistently and they do it over time. And I'm not a huge jail guy, but those guys need to go to jail. And I'd like to give the Attorney General the power to do it.
Right, and I think you bring up actually an interesting point too that plays into this as well for smaller businesses. Even when they are winning in a case that they are brought in for any sort of suit, civil, that's time away from the business. That's loss for them as well. And so even if they win in the end of the case, they're still a loser in that process because of all the time lost, for a lot of small businesses. So I mean, that's where it also becomes difficult.
Well, that's what I'm suggesting to you, and then I'll leave it there. And I appreciate the back and forth. By the time it gets to the point where there's a case, it is 99 times out of 100 clear as clear can be that the conduct is inappropriate.
Thank you.
Thank you. I just wanted to ask a quick question. I understand that from a legal perspective, defining an employee versus an independent contractor may not be that simple, right?
It is not.
But I'm wondering, based on your experience, if you can offer to us what your understanding is and as close to plain English as possible.
Well, usually they use the IRS test if you want to make it simple. I mean, that's probably the best way to describe it.
One more time.
Which is the IRS test. So.
IRS test?
Correct. It's an internal revenue test that a lot of states use. Other states don't. And in fact, there's a bill right now to change that. in Rhode Island to do something more similar to Massachusetts, which is what's called the ABC 3-point test. So you have to have certain parameters in place, like not take direction, with similar course of business. So, there are different definitions in every state, but Rhode Island seems to lead more heavily on a similar status and test as what the IRS would use.
I don't want to belabor some of the points that my colleague was making here, and I will preface, I am an attorney, but I'm not a labor attorney. I have a little bit of experience with this area. But it seems to me, based on what I remember, that if I had to summarize the difference between employee traditionally and independent contractor, I'd summarize it in one word: power, right? Does the employer have the power over the employee? Can they dictate what hours that person is coming in? Can they punish, et cetera? And so to my colleague's point, I have lots of experience as an employee. For the past 7 years, I'm grateful to have been an employer. And in between that experience, there's been a bunch of times where either I've been an independent contractor, I might have employed an independent contractor. So I appreciate the point you're making. But as I'm listening to you and some of the folks who are testifying before you, I think there's kind of an elephant in the room that we all know is there, and that is that there are people that are making choices, right? Like, God forbid I make a mistake, label somebody as an independent contractor. We understand what you're saying. But I think the reason why we're all here, we recognize it, is power. The fact that there are people in this state who employ people, the fact that there are people who come from my district, right, who might be immigrants, may not speak English, and so what we're focused on, and this is to anybody else who's testifying as well, is that relationship of power and making sure, I think that's what this bill is here to do, making sure that folks like predominantly come from my community are not on the wrong side of that relationship. And so I just want to clarify that. Thank you.
Justine.
Thank you. I want to make, there are a lot of people who want to talk, so I just want to make a brief comment because I have a lot of experience with this in Rhode Island, as my husband is an independent contractor. And I have to disagree with the point that it can be very fuzzy a lot, because I will say my husband's an independent contractor, so he goes on many job interviews. And usually the first question that he gets asked from a company he may work for is, are you interested in coming on as a full-time employee, or do you want to remain as an independent contractor, right? And sometimes, depending on the company and depending on the job and depending on the wages, he's interested in potentially becoming an employee. Other times he is not, and they say, well, we don't want a contractor, we want an employee. And he says, okay, well, fair enough, and moves on, right? Or sometimes he says that and they're like, well, we really like you, so we'll take you on as a contractor, right? So I have heard in almost all of his first interviews, which I overhear because he works at home full time, that is one of the first points they discuss is, are you going to come on, are you interested in coming on with us as a full-time employee, or do you want to remain as an independent contractor? And usually before an interview even gets into talent or position, they make that intention clear at the beginning. So I think that if a case gets as far as what Representative Knight and the Deputy Attorney General are speaking about, I can't even imagine a job. I can't even imagine you getting a job and an employer hiring you and having that be so unclear that at the end there's a criminal case. That's just a comment, and from my personal experience, that I wanted to get out there before the evening got too late. So thank you, Chairman.
Thank you. Any other questions? Liz.
Thank you, Chairman. Thank you, Committee. My name is Liz Catucci, and I'm the President and CEO of the Northern Rhode Island Chamber of Commerce. I want to thank you for giving me the opportunity to very respectfully oppose the passage of H 5902 on behalf of the Northern Rhode Island Chamber of Commerce. I don't want to be repetitive. I really appreciate the dialogue and the conversation that's going on here tonight. I'd like to second a lot of what my colleague Lori White from the Greater Providence Chamber said. And if you'll allow me, I'd like to make a few just additional points on why the Chamber is concerned about this bill. So regarding wage theft, failure to pay employees includes failure to pay wages on a regular pay day, which would most likely include a business paying employees on a bi-weekly basis without a specific exemption from the state. The fact that the wage is paid repeatedly on a bi-weekly basis could be interpreted as knowing and willful, which is what we have been talking about, a knowing and willful action, and the Attorney General could potentially decide to bring that case to court. Also included in this bill is a failure to pay an employee wages within 24 hours of separation of employment in the business in liquidating or merging. So we've seen that often now after COVID. We've seen a lot of our businesses, unfortunately and very sadly, liquidating or merging to be able to continue on. So an owner may have been paying vendors in the hopes of surviving a very difficult financial period, but if the attempts fail and the owner cannot pay the employee, a felony charge could be brought by the AG under this bill. In this scenario, the employer is subject to imprisonment, as well as a fine equal to 2 times the value of the wage. It's very unclear, we've talked about the vagueness of this bill, it's very unclear of who would serve actual prison time. Is it the CEO's fault? Is it the bookkeeper's fault? Is it the attorney's fault? The HR director? So we have a lot of questions around that because of the vagueness in the bill. We're also concerned about the changes this bill would make regarding the misclassification of employees. There's truly, in our mind, no one size that fits all definition across industry sectors, and it's why the flexibility of this analysis is so critical. It must be noted that other bills in the House and Senate seek to change the Rhode Island definition of independent contractor in order to make it more difficult for individuals to be classified as an independent contractor. If the definition changes, people who work in industries such as law, healthcare, real estate, computer programming services, facility cleaners, bookkeepers, etc., would suddenly find that they could no longer work in their chosen profession, and if they did, they would be subject to a felony conviction for doing so based on 5209. This is perhaps our biggest concern, and we feel like that's the most economically frightening part of the bill, that it's not only going to hurt the economy, but we're also really concerned about the 5,000 plus pass-through entities that existed as of this past tax year in 2022. The Chamber appreciates the Attorney General and the sponsor's intent to address the issues that are occurring in the industry, the construction industry, but if applied to all business models, we feel that this legislation could cause great harm. We ask that the committee take no further action on this legislation. Thank you very much.
Any questions for Liz? Seeing none. John, you're up.
Thank you, Mr. Chairman. Thank you for the pleasure of attending and testifying. My name is John Simmons. I am testifying on behalf of the Rhode Island Business Coalition. We are a coalition of about 25 organizations, including Chamber of Commerce, manufacturers, a variety of mostly all of the industries within the state of Rhode Island. We have about 6,000 plus employer members of the associations that are members, covering about 230,000 people. So we are a broad spectrum, and we are here in opposition to 5902. We think, as you're hearing, and I don't want to be redundant, my presentation had many of the repeats, but I wanted to bring it down to, I think, in a very simple piece. This is about consequences, in a sense of punishment versus the consequences. If you look at this in the two ways that they're looking at, is one is the wage. In essence, it is not quite, in my mind, theft, because I may make a mistake. I may do it incorrectly on the way I compute the wage. It may be something at the turn of, I'm having problems at the end of a bankruptcy, of a variety of items that I may be in the process of it, and then I may be accused and charged with a felony. That is a significant for someone who's been on the other side as an employer. If I'm being charged with a felony, that is really a chilling effect upon me on how I do it and how I can work. And so I think that the overcommitment, overwork, or overdoing of the punishment of a felony versus now it is a misdemeanor, to which, again, as I will say, Representative Knight, there is still jail time that is a possibility within a misdemeanor. I don't know if that has been used or not by the Attorney General, but it's still available. On the independent contractor here, having been on the other side of having hired hundreds of independent contractors, it is a very gray area. And to be at risk of trying to determine whether I want to have an independent contractor work, and it could be a public entity looking for an independent contractor, or it could be someone else, and also I am an independent contractor. So the ability for me to be able to make that arrangement in the way it is, and then face the issue of the employer because there was a mistake made, that there could be a felony charge. That is a punishment. I listened to the testimony from the Attorney General's office about it as being effective in the sense it's moving people. They are collecting, they are taking cases. The question is it the position of the state of Rhode Island that if you make a mistake, or if you do something on the independent contractor, that we're going to make you a felon. I think that that is a hard message for the employer community. And I know we have provided written testimony, so I'll be short so we can go on to the next 30 or 40 people that are speaking.
Any questions for John? Thank you, John. Thank you. Oh, I'm sorry. Yes, David.
Mr. Chairman, if you don't mind, this is just, as you've been testifying, I've been going through testimonies and things like that, so two key points keep popping up in the testimony, and this could be for anybody on the panel. The first point, I think the Northern Rhode Island Chamber made this point in terms of liquidation. Could you just touch on the concerns over business liquidating again? Again, I know you touched on it in your testimony, so if you could just get into more detail, just a greater explanation on the liquidation concern.
Sure. So what we were talking about was it's required within 24 hours if you're going to liquidate your business or if you're going to merge your business and you're going to separate with your employees, that you have to pay them. So this gets kind of tricky, right? Because they're liquidating or they're merging for a reason. So we're concerned that if, let's say, it takes a couple extra days or it's going to take a week to be able to make those payments, that a felony charge will be brought against them, right? That's not their intention. There's a lot of unintentional, I think, things that could happen because of the vagueness of the bill. I'm sorry, go ahead.
I was going to add to
Yeah,
that if you didn't mind.
No, please
but
do.
In that process too, if you're in liquidating, and before that, say you're trying to save the business, you're trying to do everything possible to keep it afloat, to keep it going, to save it, to make sure those workers still have jobs, and you start paying vendors for maybe more stock, or you're trying to make that last sale because you think it's going to, and then they go in and look at it afterwards and realize, well, you were paying vendors, why can't you pay your employees?
So what you're talking about is cash flow. It becomes a cash flow problem. As a company is liquidating, they're liquidating primarily because of cash flow concerns.
Correct.
And if they've made a business decision when they believed they were still viable, they were paying vendors and maybe not, they weren't, their intent was to have accrued cash later on in order to pay the payroll accruals over time. But again, because of the day-to-day business management decisions they made, they chose to use the cash to pay a vendor as opposed to the future accrual payroll.
And even not knowing it would be at that point of liquidation afterwards. I mean, you might just be thinking, okay, things are bad, you make that payment, you do that thinking it's going to get to that next step where the business is solvent, and then it's not, and then we get to that point where there is an actual trial and information starts coming out, and that's how that felony could be there.
And then another thing I keep seeing is the biweekly payroll concerns, that some businesses have been honestly violating Rhode Island law currently, paying people biweekly instead of weekly as the law requires unless you get a waiver from DLT. Could one of you touch on that in more detail?
Sure, I can touch on that briefly. I think, when we hear from members, again, this isn't coming from a business owner who's intentionally doing this, right? Well, I'm going to hold your pay. I'm going to, wait to pay you. Some of that has to do with whether they have a vendor, or depending on what their business is, they might not be able to only pay at that at that bi-weekly rate. So I think for us, the biggest concern is, I agree with, what's kind of been said before, not only from my colleagues, but from the opposition side, that, yeah, there are bad apples in this state, and they should be punished. That isn't right. Our concern is from the ones that it happens unintentionally or unknowing. I can probably guarantee you there's quite a few businesses in this state that there's confusion around whether that they're not supposed to be paying biweekly. So I'm not placing blame on anybody, but it's not intentional, is I think what I'm trying to say.
Yeah, and I'm not going to justify, breaking the law, intentional or not, but I will say that is, in Rhode Island, it's a unique scenario, number one, to have the biweekly pay. Most states that I can think of don't have that requirement. So it is a little bit of a unique scenario, so someone might make a mistake in that regard, coming in and not realizing that exists. Not to say that makes it right, but to end up a felon at the end be where it's problematic.
If I meant, just the potential of making an error, whether it's the 26, it's the biweekly pay, which is, again, it's abnormal here only on Rhode Island, versus the holiday pay, for instance. There are a whole bunch of other requirements here that you may or may not know. It could be by mistake. And again, I know I'll hear later that, of course, if it's only a mistake, then they won't prosecute. And we all know that that can't be guaranteed because of prosecution or who it might be. There's a whole variety of other reasons. So our concern is by mistake, you could be in this issue of having committed a felony. It's a difficult position. Before I want to say also, we don't condone the bad actors as well.
Right.
We wanted to do this. This is why we've been supporting a working group of the AGs and others to go after this issue. It is a fair and level playing field. But what we're considering now is that you are turning that level playing field into a very one-sided on the idea of a felony charge on these two items, and that is a significant issue for employers.
Jay?
Can I ask, what is vague about this bill? I mean, you've said it now a couple times. It says the bill is vague. So what's vague about it?
I think whether you're going to find, certain terms like willful, and, that can be somewhat subjective.
I'm glad that you mentioned that, because on my other screen in front of me, I have the pattern jury instruction for all criminal prosecutions in the Superior Court in the state of Rhode Island. It has a definition for knowing willful. You want to hear it? It says, a person acts knowingly when he or she does an act deliberately and purposefully, and not because of a mistake, accident, or other innocent reason. When a prosecutor signs an information to charge a person with a felony, they have to be thinking about what is on this page. Is it going to pass muster under that standard? And you do it long enough, it becomes like breathing. Knowing willfully is perhaps one of the highest standards of proof in criminal law. You have to prove that somebody acted knowingly and willfully and not the result of a mistake beyond a reasonable doubt. That's the safeguard. There's nothing vague about this bill. In fact, the added language, the blue stuff on the bill, is actually way tighter than the existing law now. It actually, I think, maybe protects someone. I get the situation someone's liquidating and they're like, oh my God, the world is falling apart. Let's take that example. The world is falling apart. You've tried to prop up this business. It's not working. Let's say it's a coffee shop or something. You got 2 or 3 people you owe money to, and you're like, I will get it to you by Friday, but it's not 24 hours, right? That case is not going to court. It won't meet the standard because it's an innocent act. I mean, you can't get blood from a stone if you don't have the money because your credit line has got to turn around. You got to get some money from grandma to fill up the coffers just to close out, whatever the situation is. That's not the person who's going to do that. I think the state would go after, and if they did, they would not, it wouldn't pass, it wouldn't pass the first judge. So that's what I'm saying. I mean, I really do appreciate, because we deal with this all the time, people come in where we want to lay criminal penalties for bad actions that everyone agrees are bad, but it's applicable to everyone, and a lot of people freak out because they start thinking like, oh my God, what if Darth Vader becomes our Attorney General and has an axe to grind? I mean, that's kind of how it is. But the law will protect those who are innocent.
I would argue a little bit different with it. Again, not having been on the prosecuting side, but on the other side of it, being accused of having willfully knowingly, because I did it. I hired someone. I did an independent contractor. I did it. I made it knowingly. I made that decision. The question now is I did it. I knowingly did it. I brought in an independent contractor. I may have thought it was right. So the question is, if it's now then proven later that it's not, that I made the mistake, it is a mistake, not a willful that I chose, but how do you prove the negative from our perspective, especially if you're not as proficient as you are in the law? We're reading a lot of employers look at this and become very scared about the fact that if they make a decision, they do it, and then what happens is they are subject to it. And that is also a chilling effect, as opposed to you go through the process and you prevail. There's still a chilling effect, especially if you are a public company or you are someone who's out for financing for banks, and you've got to disclose the fact that this is occurring, which we've had to do before. So the issue comes is just the idea that you can go for a felony charge based upon having a mistake of hiring someone as an independent contractor as opposed to employee. I just find it is very chilling in the way one looks at it. And so you're going to have a lot of activity now, if you've heard on the economy changing, that's going to have a chilling effect upon how we move on our economy, going to independent contractors because that's what people want. And so I just find that it's the wrong time and wrong place to put this effect into it in Rhode Island.
And I'll add to the
Thank you.
perception representative, from potential businesses thinking of relocating into the state, creating jobs in the state, to know that that's hanging out there. And even if they end up all right in the end, it's still, as John said, it has a chilling effect for potential job growth and economic growth too.
Okay, thank you for your testimony. We'll get 3 more witnesses up here. Bob Goldberg, Paul McDonald, if he's here. Is Paul here? Yes. Okay, and Dave Caldwell. Bob, you want to go first?
Yeah, thank you, Mr. Chairman, members of the committee. I do think there's one thing everybody in this room can agree upon, and that is these chairs are tough. Come on.
We
Thank
sit in
you
the
for
same
calling.
chairs. We sit in the same chairs, so don't worry about it. We're here longer, so.
I wasn't hesitant to come up here, but it was tough getting in and out of this chair. On a more direct note, I'd like to begin by saying that this employment classification is a very, very unsettled area of the law, both federally and statewide. I've spent a lot of time in the last few months examining the laws of many states. This bill before you is by far the most draconian bill in this whole area of the law, state, federal, or anything. And I want to just backtrack a little and get to Representative Knight's question about what's void about this bill. Well, misclassification depends on who you ask and what tests they apply. Fair Labor Standards Act has one test. The IRS has a completely different test. The common law is a different test. And the newly evolved ABC test is a different test. So the vagueness in this statute comes from under what test are you gauging misclassification? I would suggest to you respectfully that this piece of legislation is void for vagueness. Could any of the lawyers and even the lay people, because I can't do this, explain what the elements of misclassification are that a judge has got to instruct a jury? As Representative Knight so ably pointed out, each and every element of the offense has to be proven beyond a reasonable doubt. You can't have 3 out of 4 or 4 out of 5, each and every. Well, what are the elements in this statute of misclassification? They're not there, they're not listed, there's no definition. Particularly when you have the Fair Labor Standards, you have the IRS, you have the common law, you have the new ABC test, which incidentally can never be satisfied under the favor of an independent contractor. Everything there comes down as an employee. But that is the vagueness in this. I'd also like to point out there's another statute I came across in this, my research in this matter. It's 281422. It struck me as a very odd statute. It's entitled Duties of Attorney General. It shall be duty of the Attorney General to prosecute actions, both civil and criminal, for those violations of this chapter that come to his or her knowledge and to independently enforce the provisions of this chapter. Very odd. I thought that was already the Attorney General's constitutional duty. But this whole chapter has a prosecution, recall there's already a misdemeanor in there, has a prosecution vein to it already. As the representative pointed out, if you're facing both civil and criminal, you're almost compelled to take the Fifth Amendment in the civil, let the fines go where they may, so they can't use it against you in the criminal action. That dual prosecution comes up in several areas of the law, but it is a real problem for defense counsel. I'd also like to bring to your attention, the state of Rhode Island has over 2,000 independent contractors on the payroll. How did I get that? Right off the internet. I got their names and addresses and what they got paid. It's all public knowledge. That'll give some people a thrill, but now all of a sudden they want to outlaw it in the private sector. What's going on here? The independent contracting is at the very core and fiber of the business world in Rhode Island. It touches all aspects. Some people were very surprised to hear most dental hygienists are independent contractors. Many emergency room doctors are independent contractors. Traveling nurses frequently are independent contractors because you can't get the specialty nurses you need any other way. This goes far beyond. Now, there are several approaches that some of the states have taken to this problem. I want to talk about California first, because California is out there, both legally and geographically. California took the approach of, well, let's pass a bill that makes it a felony, but even under California law, the felony is not the first step. You have to go through several violations, et cetera, until they get to the felony. But even California had something like 15 exceptions to the law on independent contracting, where they're allowed. All of those exceptions apply here. The other path that has been taken, particularly by Pennsylvania, New York, Connecticut to some degree, is a laser focus on the construction industry where the bulk of these problems exist. This, I want everybody's fair's fair for everybody. Wait a minute, small steps. Let's see what the real problems there are, how much is attributable to the construction industry, and I do believe the construction industry needs adequate protections in the bill as well. But in the construction, when you have that laser focus, they have stop work orders, cease and desist orders, they have revocation of the right to do business in Rhode Island, all those types of things prior to the felony or in addition to the felony. That should be the approach that's tried here first. Another thing, there's an interstate compact on this very problem. Rhode Island hasn't even joined it. Why not? I have no idea. I raised this a year ago. Why isn't Rhode Island part of the interstate compact? So you can identify the bad players. No response. Crickets. It's a very easy thing to join. It's managed by the Wage and Hour Division of the U.S. Department of Labor, and it's a really clearinghouse to help states with this very problem. It is a problem, and by the way, I'm here on behalf of the Providence Chamber of Commerce. It is a problem. We're not here to defend wage theft or misclassification, but we don't know what misclassification is. Another very curious thing that I saw in the actual statute is on page 1, line 15, it makes failure to pay union dues wage theft. Now, failure to pay union dues is a problem in and of itself, but why is that included in wage theft? And for Representative Knight, that's 2814.3. And now, while this bill says the employer, the employees are equally at risk here. Under the Rhode Island conspiracy statute, I think it's 1116, they're equally culpable. It takes two to tango, and with the same penalties, all of that. Now, you have a lot of people, a lot of good, honest, working people, and I don't mean to pick on firemen, but they seem to be the most mechanically talented group that I'm aware of. They're either, in addition to being fire professionals and health professionals, they're either competent electricians, competent plumbers, or competent carpenters. Most of them have the ability to work on other jobs. This would sweep them up in that problem too. Everybody's at risk with the passage of this legislation. There are many other technical drafting errors in here that I won't monopolize the time of, but I would suggest, even, what's a second offense? Is a second offense is I hire A, B, and C. So A is a misdemeanor, okay, and C and D then become felonies because they're misclassified? Or does that definition itself need honing in? Is it per job? Is it per time frame? Is it after conviction? What is it? It's very unclear here and very unfair there. There's a lot of things I would respectfully suggest have not been thought out in this bill. But I see Representative Knight's wheels turning about 2 million miles an hour, and I would ask you, if I could directly, what are the elements that a judge is going to describe to?
My mic is over here. I'm done.
Oh, come on. But seriously, all of you, what are the elements the judge is going to tell the jury? You have to prove this, 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 and this for misclassification. There's nothing in here. You use FLA. Do you use IRS? Now, the IRS itself has a program where if you can't understand their rules, they even have a form for it. You fill out this form and ask. Unfortunately, it takes 6 months to get an answer on that form. But I would respectfully request that this bill is not ready for prime time, that it needs definition, it needs fine-tuning, and it's unfair to the citizens of Rhode Island. Even one last thing I kind of amused me. I started looking this up in the fall, and I saw, as I was looking it up, the Department of Transportation was advertising for more, quote, independent contractors to serve as roadside road plowers. And boy, the duties and all of that, boy, they matched up the employer. Come on. This is just not ready for passage to become a felony. The most egregious violation in the criminal law is called a felony, and this is not warranted by the terms of this bill. There are better ways that other states do to combat this problem, and Rhode Island should take a look at them. I would suggest Connecticut, Pennsylvania, New York with their construction laser focus. And thank you for your attention.
You ready? Oh, I'm sorry. So Jose, go ahead.
So I think I have a couple of points, and again, prefacing I'm not an expert in this area of the law.
Me either.
I think that in common law in Rhode Island, we have a test with various different factors for determining what is an employee versus an independent contractor. As I stated a few moments ago, it seems to me that the most common element amongst all those is power. Who holds the power in the relationship, right? Independent contractor is a lot more fluid. Maybe I show up when I show up. You pay me a flat fee as opposed to an hourly fee, and that's why people are more inclined. Yeah, it's more flexible for the individual, but it's also easier for the employer. And so if a judge were to make a finding, right, this person, if they would have worked under the standard minimum wage laws, would have made X. But because they are an independent contractor, they're making at least $1,500 less than what they were supposed to make. Which leads me to the question that I want to ask you. Am I understanding you correctly when it sounds like the defense to this is that most people, and I want to make sure I'm understanding, so if I'm wrong, please correct me. Is it your position that most people that engage in independent contractor relationship are doing so voluntarily, and therefore this bill will get in the way of that? Is that basically what you're saying?
I would say that there are an awful lot of people in the state of Rhode Island, and no, I don't have the number, that voluntarily prefer to be independent contractors, and there's a lot of advantages to it. But I would also say every case is different. But I would just take a moment. I heard your questions earlier, and I would like to compliment you on your analysis of the common law in Rhode Island, and that what you've stated is essentially the common law test. But that's not for the judge to decide. That's for the jury to decide and the judge to charge them on.
So a lot of what you said sounds almost identical to what I was saying about...
No wonder I thought you were right.
And the point that I'm trying to make is, as I understand this, again, it's not just a question of misclassification. It's a question of misclassification resulting in wage stuff. And so if your position is most people are independent contractors because they choose to be, my rebuttal is I wonder how many of them would continue to choose to be if they see that they're losing $1,500 in wages as a result, $5,000 in wages.
Respectfully, I don't think you can draw the conclusion that they're losing money. Independent contractors run the gamut from the most trained, highly professional people in the state, MDs, down to just about anybody else. And frequently they want to be an independent contractor because they can command a higher hourly wage. The company needs you. They need you now. You can get more. The company knows it's not forever. It's a short term. We can pay this. And that independent contractor can have 5 different companies he's working for simultaneously.
I can appreciate that because I am an independent contractor right now.
Me too.
And so I, appreciate appreciate the flexibility. I love it. But I also am an attorney who can defend myself. And if my relationship with those folks that I'm working for were to change, and all of a sudden they're telling me when to show up, even though it may start one way, right? It starts at the beginning, flexible, work from home, do whatever you want. But the minute that changes, and sometimes it's subtle, now all of a sudden, you're paying me at this grade, but you're expecting this much work. And I think that's kind of what we're trying to focus on.
I would respectfully suggest that is kind of one of the outlier situations, and not given the independent contractors now include, as I said, the medical professionals, the computer people, the college graduate gig economy people, the prefer to work from home people. It's not just that, but to touch on what you also said, the misclassification and wage payment are linked. There's no question about it. The way they get you coming and going is you misclassified, not only did you do that, but you also owe money for that. But many of the misclassifieds are making more than the hourly people. And I don't think we can draw an across-the-board conclusion in that regard. But it's more than, control is more than just hours of show up.
Agreed.
Dave Caldwell.
Thank you, Mr. Chairman, members of the committee. I promise I'll be quick. I appreciate the opportunity to testify today. I don't know the gentleman on my left or right, but I gather the chair wanted the bald white guys in one shot, so I will make that quick.
Bald white guys in one shot.
Yep, there you go.
I thought he said tall.
I'd go for that too, but I know it's a long night. Our company has been in business 55 years. We had our workman's comp audit on Tuesday. We came through in flying colors. Personally, this won't affect me at all. It would be good for the larger operators to get rid of the bad guys that I know are out there. I'm here on behalf of the Rhode Island home builders with some concerns about the potential impacts on our very small and emerging contractors in the home building industry, just to make sure that the punishment fits the crime, if you will. That's largely our concern, is how it will affect our very small and emerging home building contractors as they're trying to figure out and do the right thing. I'd be happy to answer any questions.
Any questions? You've got three other members too here with you, don't you?
Yeah, they're much smarter than me, so
Okay.
they can answer the questions, but that's all.
Thank you. Mr. McDonald.
Good afternoon, Mr. Chairman, ladies and gentlemen, committee members. I couldn't help but listen to my good friend Bob Goldberg talk about his hysteria, or whatever it's called, but I suggest make the chairs a lot harder. I am the legislative director for the Teamsters Local 251. I also enjoy being president of the Providence Central Labor Council, an organization of 30,000 plus members. I'm also a member of the Rhode Island AFL-CIO and serve also as a member of the executive committee. And in addition to that, I'm proud to say that I am the oldest dues-paying Teamster in America. And I'm sorry I'm bald tonight.
I'll let that go.
On behalf of the 6,300 Teamsters, though, that I represent, thank you and we ask you for your support of Bob Craven's Bill 5902. This bill's headline should be crime prevention. A crook is a crook no matter how you spell it, and we got too much of it going on in this state. I've heard an awful lot already, a lot of what ifs. Well, what ifs, and that's the way it is. But if you're a good businessman, you should know how to conduct your business. And you should have people around you that will make sure that you will not violate any kind of laws that do with wage theft and misclassification. Wage theft remains a significant issue in Rhode Island. About 400, excuse me, about 400 complaints are filed annually. And while 40 or 50% of them are dismissed, 50% of them go forward. That ought to tell you something alone. But for those honest business people, they're probably in the 40 or 50%. So what is their fear? I tell you, the fear is that if you're not doing things right, you deserve the penalty that goes with it. It's gone on too long, stealing money out of the pockets of blue-collar workers, people that work hard in all kinds of industry, whether it be in housekeeping industry, hotels, you name it. There's always someone with an angle to try to make an extra buck, and it's not good. It hurts the honest Rhode Islander. It hurts Rhode Island's economy. Misclassification allows the cheats to avoid payroll costs. It leaves the workers without unemployment, no TDI, no workers' comp protection. How would anybody in this room feel if they worked for someone and they got injured on the job and they said, oh, gee, I got to go to the hospital and now it's going to be workers' comp and, oh, you don't have nothing. No, we have nothing, no record of you. That would be terrible. No TDI. That would be terrible. Unemployment. You can't collect unemployment when you work for these crooks. This bill would give the Attorney General the tools he needs to bring the bad actors to justice. And they would help the crime victims, because that's what we are who get cheated out of our wages and our benefits. We're crime victims. So I ask you on behalf of all the people that I represent, the Teamsters Union, the Central Labor Council, please, please pass this good legislation. I'd be glad to answer any questions you might have.
Any questions, Mr. McDonald? Thank you very much. Okay, we've got three other members from the Builders Association. Bob Baldwin, come forward, and Johnny and Alex from the same group. Oh, great, okay. Well, let me get one more witness then. Dorothy Dawson, or is Dorothy here? Yes, come on, come forward. From ACEC?
ACEC Rhode Island?
Yep. Well, it doesn't say Rhode Island, it just says ACEC. Okay. Why don't you go first?
Okay. First of all, thank you for having me here this evening and listening. Oh,
Is
the
the
mic's
light
on
red?
now. Is the mic on now?
Yes. Could you bring it a little closer to you?
Yes.
A little more close.
A little more close.
There you go.
Good evening, Chairman and committee members, and thank you for hearing my testimony this evening. My name is Dorothy Davison, and I'm the Executive Director of the American Council of Engineering Companies of Rhode Island, or ACECRI. ACECRI represents over 50 engineering firms and employs about 800 plus technical workers who provide engineering services to and in the state of Rhode Island. ACEC Rhode Island respectfully opposes 5902 in its current form for very many of the same reasons that you've already heard this evening, almost point by point. So I won't belabor the report and repeat everything they said. I will rely on my written testimony, which I've also submitted, and I'm happy to take any questions.
Any questions? Thank you.
Chairman and committee, my name is Alex Mitchell. I am president and co-owner of Meridian Custom Homes. We're a home builder here in the state of Rhode Island, building in about 9 different communities at any given time. I'm also the secretary of the Rhode Island Builders Association. And while I fully support the intentions of this bill, I cannot support the bill with its vagueness and its unclarity and the concerns that I have in terms of how it will impact the 40 to 60 different subcontractors that we hire on an annual basis and their ability to expand, to take the risks of expanding, hiring other people, and potentially getting faced with accusations of a felony and a criminal accusations like that. Very scary, very scary. And if that impacts their ability to expand and grow or to create new businesses, that's going to impact our ability to build the homes that we need to build in this state. And if it's impacting us, it'll impact other builders and renovators. And it's the exact opposite of what the state needs at this time.
Any questions? Thank you. Bob.
Thank you, Mr. Chairman. Members of the committee, thank you for the opportunity to testify. My name is Bob Baldwin, third-generation home builder, past president of the Rhode Island Builders Association. And I first of all want to applaud that this bill has come to the attention. To have employees be shortchanged on their wages is absolutely abhorrent. So most importantly, I want to get on the record for myself and for the Rhode Island home builders that we do not tolerate in the tiniest way, and we truly wish the bad apples would be punished as they justifiably should. With that in mind, I just want to make one observation for the record. We've heard previous testimony from the AG, from Greg Mancini, and from others, that this focal point, including with a couple of people just prior to us, the worst number of incidences are in large construction companies with outside-of-state vendors. Fine. One observation. This bill does not just apply to them. this bill paints the same brush to every potential independent contractor in the state of Rhode Island, both big and small, and impacts the smaller construction companies in a much more difficult way than it would the larger companies that have bookkeeping staff and personnel that the smaller contractors just do not have. We feel that this is a broad brush, and the bigger problem with this is that it punishes the people who are trying to get into the, trying to become independent contractors, trying to create their own companies, the tradespeople that want to do this themselves, and run the risk of making a mistake. There's no provision for a mistake in this. If someone makes a mistake, it's an automatic felony charge. We find that to be egregious. It's going to hinder new companies from expanding, existing companies from expanding, and particularly with companies who want to become, or tradesmen that want to become independent contractors. This is going to have a deleterious effect on them doing that. They run the risk of making a mistake, and when people get into our industry and go from tradesperson to a contractor and having their own company, they make dozens of mistakes. This is a problem for them. And they don't have the expertise, they don't have the experience. It's not intentional at all. I've been in this business 40 years. I've seen a lot of people get started. There's companies in this room that were started out as very small companies by somebody who wanted to start and go on their own. This is going to present a massive problem for them, especially in the minority communities where we're trying to get them into the industry right now, where they have language barriers besides. And that, for this to be a felony charge right out of the box is truly egregious. And thank you, Mr. Chairman and committee members, and I gladly answer any questions.
Any questions for Mr. Baldwin? Okay, thank you, guys and ladies. Next is, let's see, Ben Burchard from the Carpenters Union, Lynette Forey-Menard from RIMBA, and Terry Martesian from RILBMDA. Getting an alphabet letter. Okay. And is Ben here from the Carpenters Union? Maybe he's outside. All right, let me see if I can, let me see if I can get anybody else up here. Dan Brianco from the, Brianca, you can come up. And Richard Pacheco? Is Richard? Okay. No, you left it blank, so I was just making sure. And David, yes, I do. And Richard Molina Hernandez, does he wish to testify? Okay, all right, so you two, and then we have one other witness that wishes to testify. Lynette?
Thank you, Mr. Chairman, members of the committee. My name is Lynette Forey-Menard, and I am here on behalf of the Rhode Island Mortgage Bankers Association and the New England Convenience Store and Energy Marketers Association. Full disclosure, the Northern Rhode Island Chamber of Commerce is also a client of mine, as is the American Council of Engineering Companies, which you just heard from. The reasons that the mortgage bankers and the convenience stores oppose this bill is very much what you've heard already. So I will not repeat that, but what I'd like to do is to talk about independent contractor and even why I fear it as an individual. For 23 years, I have been an independent contractor. I know in other venues, a number of things have been said about what we do and do not pay. I do pay taxes, income taxes to the state. I pay income taxes to the federal government. I do pay Social Security tax. That was a big question that came up in a previous hearing. Not only do I pay the employer side of the Social Security tax, I pay the employee side of the Social Security tax. So someday, I hope to collect. I have qualified, happy to say. I have liability insurance. I have long-term care insurance. And until I got married in 2019, I paid my own health insurance, $9,000 a year. So I am doing it right. I do my best. And Representative Batista talked about power. That's part of my concern. The clients that you heard from today decide which bills they're going to oppose and support. They decide if I'm going to be giving verbal testimony. They decide if I'm going to be just doing writing testimony. They have the power to make me sit in this room. Tuesday night, I was in the building till 10:30 at night. I was here yesterday till 8:30. They have that power over me. I still choose to be an independent contractor. Many of you that know me know I love to travel. That's the reason I work. And being an independent contractor allows me to travel when this legislature is out of session. It's what I want to do. It was my American dream. Bob Goldberg talked about the fact that there are other tests that are being discussed. And that is the part that scares me greatly about this bill. Because if, in fact, the test changes and it becomes a felony to have an independent contractor that can't meet the test, then I could be out of my job. My clients may not be able to hire me. And if they did move me over as a W-2 employee, think about how that would work. I'm sitting here basically for 5 clients. If I get up from this table, if I'm in W-2 for each one of those, and I get up from this table and God forbid fall, you've all seen me on crutches for 4 months, if I fall and hurt myself again, I ask the question, which one do I go under workers' comp under? If one of them chooses not to renew my contract, do I get to collect unemployment comp while I'm working for everybody else? It confuses the whole situation. So, Mr. Chairman, for that reason, I would personally oppose the bill because of those other tests and how they can interact together, and my clients do. Be happy to answer any questions.
Any questions? Seeing none, you're up.
Thank you, Chairman Craven, members of the House Judiciary Committee, and all the co-sponsors. Thank you for the opportunity to address you here today. My name is Dan Bianco. I am the Vice President and New England Regional Manager of the Laborers International Union of North America. On behalf of the over 12,000 members of the Laborers International Union of North America in Rhode Island, I am here to support H5902 that will make wage theft and worker misclassification a felony. Employers that knowingly and willfully do not pay workers their wages and or misclassify them have a devastating impact on our local economy, taxpayers, and workers, especially those in underserved communities. Wage theft and misclassification cost our states millions of dollars in uncollected income tax, unemployment insurance, temporary disability insurance, and workers' compensation annually, and vulnerable workers are left to exploitation by their employers. Treating wage theft over $1,500 and misclassification on the same level as other thefts sends the message that Rhode Island does not stand for deceptive business practices that injured hardworking members of our community. You have heard from those that are in opposition to this bill that it is bad for business. Well, it's bad for those businesses that don't break the law and play by the rules. You have heard that businesses are afraid to be wrongfully accused for an honest mistake. Well, let me tell you, I am confident that the Department of Labor and Training, the Attorney General, and the state of Rhode Island know an honest mistake and what is knowing and willfully a violation of the law. This bill is not only good for workers, taxpayers, and the state, it is good for businesses that follow the law. H5902 will serve as a deterrent to violators and level the playing field for responsible employers who follow the law. This legislation is not only pro-worker, pro-business, and pro-Rhode Island, it is pro-everyone. I urge the committee to pass H5902. Thank you in advance for your consideration and your attention to so many issues that affect the members of my union. That concludes my remarks, and I will be happy to entertain any questions from the committee.
Any questions for Dan? Thank you, both of you. Thank you.
Thank you.
So is Sam Kramer here? Sam, you could take the chair, and Michael Sabatoni. Mike, you'll testify last. Go ahead, Sam.
Hi, good evening, Chairman Craven, members of the committee. Thanks for listening tonight. It's been a long testimony, so I'll keep it as brief as I can. There's been a lot of talk this evening about fear of over-prosecution, right? The specter of over-enforcement. And let's talk about reality for a minute, right? The reality that we live in is one of chronic under-enforcement. That has tremendous costs. You've heard about them tonight. Hundreds, maybe thousands of Rhode Islanders going without wages that they've earned. This has a real impact on people's lives. Across the nation, it's costing billions of dollars. The enforcement mechanisms are so paltry at the moment, and you heard the Deputy Attorney General testify to this earlier tonight. Certain businesses just bake this into the cost of doing business. Take the savings from underpaying, pay the fine, move on. Well, what does that really mean? Living in a world of chronic under-enforcement. It means that we're allowing private companies a subsidy, right? They are making more by paying less, and the people who pay for it are the workers who don't get the money that they earned, and the people of Rhode Island who have to pay taxes into the social safety net that will prop those people up when they don't have enough money to buy their groceries or pay their rent. Right? It's a massive transfer of wealth from the poorest among us to some of the richest among us. It's a problem, and the mechanisms need to be in place for stronger enforcement of our wage theft laws. We've talked a lot about, I think, vague principles. I represent individuals. I represent individuals who complain about wage theft. I think it's important to think about who this really affects. We've heard a lot about the construction industry tonight. I can tell you it affects people all throughout industries in Rhode Island. I've represented people who work in janitorial services, people who work in restaurants, people who work in administrative capacities. Restaurants, in fact, food and beverage service is one of the places where this is most rampant, right? And that's in part because of like the strange minimum wage laws surrounding tipped employees and what you need to do to comply with the minimum wage laws for tipped employees. But I think anybody who's worked in a restaurant will tell you every now and then, you're just going to get stiffed. I mean, people go into that job knowing that if you're working at an unscrupulous restaurant or a place where business is bad, you might end up not making a minimum wage. It's wrong. And when businesses do it intentionally and knowingly, they should be held to account. Right? Nobody likes being held accountable, right? But unless we have mechanisms to effectively hold people accountable who are intentionally and knowingly robbing poor people of their hard-earned wages, we're going to be distributing wealth in the wrong direction, hurting our communities, and spiraling certain members of our communities into poverty. Right? The other work I do in Rhode Island is representing people who are facing evictions. Right? Too many people don't have enough money to pay the rent right now. And that's in part because they're not making enough money. And when so many people who are working minimum wage jobs or close to minimum wage jobs, right? You know what it's like to live on $13 an hour? You can't make ends meet. Now, what if your employer takes 20% of that because just chronic underpayment? All of a sudden you're making, what, $11 an hour? You're not going to pay the rent. You can't pay the rent. You can't pay for groceries, right? We need chronic and strong enforcement to keep people from spiraling into poverty and keeping and preventing everybody in Rhode Island from paying the consequences for that, because they're severe. So for that reason, the Rhode Island Center for Justice supports 5902, and we'd like this committee to do the same.
Thank you. Okay, Michael, you are the last witness.
Last but not least, so Mr. Chairman, members of the committee, first and foremost, thank you for sponsoring this most important piece of legislation. I've been up here since 2007 trying to get a fix to a chronic problem that plagues not only the construction industry, but the system as a whole. And I'm going to talk to you about the what-ifs versus the facts. I'm not going to play three-card Monty with tests or ignorance as a defense or our trust in the judicial system or our departments of labor and training, the workers' comp system currently, that utilizes a test, that the penalties are far severe. You heard George Nee mention the reform that happened in the 80s, and the business community since the 80s has not been up here saying it's very vague. We don't know. What if? There was a recent article in the Journal on Tuesday, and every legislator should read this article, and if it doesn't get your hair on fire about why the system is broken. The state actually had to go, I'll call it, and get a divorce from a contractor that was chronically paying the system. Maybe not with independent contracting, but not wage theft, but a slew of other things, including insurance fraud, shoddy workmanship, opening up shill companies over and over again. Reason why he could do this? No deterrent. It's too lucrative for employers, bad employers, to play this game. And it is a game. The system is broken. I have full faith and trust in the system. If I rob you with a gun, if I rob you with a physical threat, or any other type of object, $1,500 or more, it's a felony. If I sit at my desk, knowingly and willfully rob you with this, it's a misdemeanor. And it happens time and time and time again. This contractor, knowingly and willfully, has been violating the law. If this law was in place, I would probably suggest he would have cleaned up his act a long time ago. But because of the system, he continues to perpetuate theft and unscrupulous business practices that undermine the rightful business community in the state of Rhode Island. I work closely with Laurie White in the Providence Chamber. We're members of the Providence Chamber with our labor management groups. I'm a pro-business, pro-labor leader. I've been at this a long time. We're members of the Northern Chamber. I want a vibrant business community. That's what we all want. Economic development, build things, invest. Allowing the misclassification of workers as well as the wage theft of workers is not my idea of a vibrant economy. And I would probably suggest more than over 95, maybe even higher than that, of the members of those chambers will not be impacted by this law. What if I make a mistake, ignorance, knowingly and willfully? And as Representative Knight has said so eloquently on a few different occasions tonight, that's a pretty high threshold. And knowing a little bit that I do know of how things work around here in the different agencies, if you make a mistake and if you're honest, then guess what? There'll be a system for you and you will never get to that point. But if you do this, like this contractor did in the paper on Tuesday, I agree with some of the comments I heard from the panel tonight. You deserve to be prosecuted. It is too lucrative, especially in the construction industry, to continue to do this. We've had studies, 2007, 2022, that tell us how much tax revenue we're missing. That's just the revenue coming in. I also heard the testimony of the benefits you don't get. Temporary disability, unemployment. Now, are there rightful independent contractors? Absolutely. Do they have a place in society? Absolutely. Can it be done the right way? Absolutely. Are there checks and balances in the system currently? There are tests being utilized at workers' comp and DLT right now. Right now. Every single day there is adjudication in those agencies right now using a test. I don't hear anybody complaining about that right now. The system works. The problem is there's no deterrent, especially when it's a misdemeanor. Most of the companies that come in here and do wage theft, specifically, are out of state. And usually when the workers get robbed that show up at my union hall and the union halls from the rest of the building trades, when they come when it's too late, they're gone. Most notably, most of them come from New Hampshire. Come down, they do a job. Construction has different services at different times. Week care, 3 weeks, 4 weeks, 6 weeks. You know when you usually get robbed? Your last week or two. If you got a couple weeks left on a job and the employer doesn't come with those paychecks, he says, no, we're going to give you the double check next week, well, you better watch out, because he's going to ride over that line, and it's only a misdemeanor, and we can't have any extradition, and the game is over, and the worker gets harmed. I've been at this a long time. I think it's time that the House steps up and passes this once and for all. This bill is as simplistic as it can be. Let me say that again. As simplistic as this can be. This does not change the system that's currently in place. Changes one thing. Changes one thing. It changes the penalty if you knowingly and willfully commit wage theft or misclassify. That's it. In a nutshell. That's it. I'd be glad to answer any questions. I'll just close with this. The governor, lieutenant governor, attorney general, Department of Labor, the Senate, every general officer in the state of Rhode Island supports this bill. I need the House to support this bill. Let's get the deterrent that we need. Let's support the rightful businesses in the state of Rhode Island that play by the rules every single day, and not allow companies that want to play the system because it's too damn lucrative. And again, go back and read that article on Tuesday, and you'll have all the evidence you need that the system is broken. And I'd be glad to answer any questions, and I appreciate your time.
Any questions? Oh, Jose.
Thank you very much for your testimony. There's been a lot said about construction today. At the beginning of your testimony, you said it's not just construction. Could you educate us a little bit as to some of the other places that this is happening?
You've heard some testimony. The service economy is plagued with it. We have, the food service workers, housekeeping, janitorial. I mean, you can go on and on. Construction is really lucrative because of what we do, and there's a transient nature of what we do. We're always moving around. So that just lends itself for a lot more easier exploitation for wage theft and misclassification. But there are other industries that I had mentioned, those being more specific, that are exploited. And a lot of times, unfortunately, especially in those industries, it's the most vulnerable in our population.
Any other questions for Mr. Sabatoni? Thank you very much.
Thank you.
Thank you. And that concludes testimony on House Bill 5902.